Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So I am going to now move over to introducing Gideon Kracov, who is our moderator and who has put together this panel today for us. Gideon is a distinguished mediator with 30 years of experience in civil, real estate, and environmental matters. He's been described as a highly collaborative and a pragmatic mediator, and today he will lend his significant real property expertise to our presentation. Thank you for joining us, Gideon, and for assembling this fantastic panel of speakers.
Hey, thanks. Thanks, Katie. I'm not seeing the slides. Are they up on the screen here? There we go. Okay, everybody. Okay, welcome everyone to Good Fences Make Good Neighbors, Resolving Easement, Title, and Homeowners Disputes. The title for today comes from the Robert Frost poem, Mending Wall, that explores the annual ritual of 2 neighboring farmers rebuilding the wall that separates their properties. One party questions the wall's purpose, arguing that it hinders neighborly interaction. His neighbor instead repeats the proverb, good fences make good neighbors. You know, I'm looking here. We have at current count over 400 participants today. That's a lot. It almost makes me a bit nervous to meet everyone's expectations. The topic obviously resonates even 100 years after Robert Frost's poem. Let me introduce our panelists very quickly. Zach Schorr is a trial attorney at Schorr Law in LA, where he focuses exclusively on real estate law, from advice to litigation to appeals. He's lead counsel on several recent published Court of Appeal cases that have shaped the law of easements in California. He served as first chair in over 50 real estate trials and has handled hundreds of neighbor disputes. He also has a terrific, dry sense of humor that I hope we get some glimpses of today, Zach. Stephanie Goldstein is a seasoned real estate litigator and trial law partner at Schorr Law in Los Angeles with Zach. She provides advice and general counsel on a wide variety of HOA matters. She's a contributing author to the Continuing Education of the Bar, CEB, California Title Insurance Practice. Stephanie and I are newer friends. We just met 2 months ago as part of a lawyer networking group. And now, Stephanie, we're doing a CLE together. It shows for you newer lawyers, get involved in professional events, show up, it really does pay off. And my name is Gideon Kracov. I'm a moderator today. I mediate, as Katie said, for ADR Services in Los Angeles, specializing in real estate matters. Lawyers and clients hire me to help them resolve their real estate disputes, the things we're talking about today. I serve on the adjunct faculty at Loyola Law School, where I teach land use law and dispute resolution. I'm the former chair of the California Lawyer Association Environmental Law Section and current vice chair of our own LA County Bar ADR section. So let's go to the next slide, to the agenda. So do you get client calls or referrals concerning neighbor disputes? So if so, this panel is for you today. Let's go through the agenda. First, Zach's going to give a quick refresher on the kinds of easements. Yes, these are ancient doctrines, but there's a surprising amount of developments in the area and new case law all the time. It hasn't stayed static since your law school days. Next, Stephanie is going to give practical advice on how to assess easement matters after the client contacts you. How do you deal with surveys, experts, and how do you interpret the recorded documents? Third, with his years of learned experience in easement and title litigation, Zach's going to discuss lessons learned, law and motion tips, and dive into remedies. And that's going to lead us into quiet title litigation and Liz pendants practice tips. How do you get Liz pendants on title? How do you remove them? And what are the consequences for the loser? Stephanie's then going to present on working with title insurance. She's going to go over the contents of the policy, submitting claims, dealing with the insurer, and the scope of coverage. Zach's then going to speak to HOA, Homeowners Association matters, and the Davis-Sterling Act's ADR requirements, interpreting covenants, conditions and restrictions, the business judgment rule, and the role of insurance in HOA cases. And then I'm going to sum it up with some ADR and settlement tips. These neighbor cases can be emotional and hard fought. What are the best strategies to get them resolved? So we have a lot to cover today. Let's dig in. We're going to start with Zach on the next slide.
Good afternoon, everyone.
And let me just, I'll frame it for you. There's a lot of
Thanks.
evolving case law in this area, Zach. It seems like once a quarter, we see a new published case, perhaps involving equitable easements. And Zach, you're going to give us a bit of a refresher on this area of law.
Yeah, so this is a sort of ancient area of law, and a lot of easements have, at least in California, have been around hundreds of years, but the law is still evolving, and we've been fortunate enough to be a part of some of the more recent cases, including the Botta versus Hunt one. So I'll just start with a quick overview of what an easement is. I can give you a legal definition of it, which is on the screen. My simple non-legal definition is it's the right to use somebody else's land, or it's the term I use is extraterritorial rights as a way to think about it. And most people, when dealing with title and interest in land, they think that the actual boundary lines, the legal description, is the end-all be-all of who owns what and who has a right to use what. But through time and through different theories, you can gain these extraterritorial rights. So I'm just going to give a quick overview of different types of easements. This is a very short seminar, so I'm going to go as quick as possible, but you could probably spend 8 hours on each of these. One type of easement that we frequently see are implied easements. Those are easements that evolve basically when there's a common ownership is split, and then there's an implication that the type of use that preceded the ownership split continues beyond, but it's not a recorded easement, so someone has to sue or bring a quiet title action. The Botta versus Hunt case is a good reference point for this is our decision. In that case, they saw it implied and prescriptive and express, but the sort of the background, the lead up from the Court of Appeal, they go through a lot of the different types of easements. So if you wanted a quick refresher, that would be one of several good places to start. Second type of easement is an equitable easement. That's an easement that came about essentially in the 2001 case, which is also on your screen, Hirschfeld versus Schwartz. This judge made law that basically decided that if you have a permanent encroachment, there are going to be certain situations where the court will allow the permanent encroachment to remain in place, even though it doesn't really fit within any of the circles or squares of the other types of easements. So in order to get an equitable easement, there's three essential elements. Must be the trespass or the encroachment must be innocent. That means it cannot be negligent. It can't cause irreparable injury to the public. And then the court gets into a balancing test to see whose interests are tantamount, or who's going to be burdened most. So they're balancing the hardships is, I think, how many of the cases describe it. With equitable easements, this isn't on your screen, but there is a provision that many people don't know about. If you are successful in getting an equitable easement, then there is a provision in the law that allows the court to make the person, the dominant tenement who's going to have the easement, make them have to pay for that portion of the property that's being burdened with the easement. I'm going to keep moving. Another type of easement is prescriptive. This is probably the most widely known and widely used / misunderstood. It's essentially adverse possession minus the taxes. So you've got open and notorious use, continuous and uninterrupted for 5 years. It's hostile and averse and under a claim of right. Interesting little footnote on a prescriptive easement is there is a jury trial right, and I have done a jury trial on prescriptive easement. So that a lot of people don't know that. So most of these are equitable remedies. Another type of easement is an easement by necessity. That's like the sister or brother, I would say, of an easement by implication. That's where you have common ownership, there's a split, and then you have landlocked land. Try to keep my slide to 5 minutes or less, but that's essentially a very bare bones overview of different types of easements.
Can I ask you a few questions there, Zach?
Sure.
What about exclusive rights? When you have two neighbors, maybe one of the neighbors has been using the property for a while, perhaps it's a driveway, and they want to fence it. Can you have exclusive rights to somebody else's land? And does it depend on what kind of easement we're talking about, whether it can be exclusive?
The only type of exclusive easement that exists under a law is, and I didn't mention these in the description of easements that I went through. There is such a thing, obviously, as an express easement. I can be Gideon's next door neighbor and grant him an express easement to use the driveway, to use your example. And so, as a subset of an express or an easement that's granted through a deed, you can have an exclusive express easement, which says Gideon gets to use my driveway and I cannot use it. But that's the only circumstance under the law where you can get an exclusive easement. It has to be express, and it's going to be like a traditional easement that your title company would pick up. See, people often argue for a prescriptive easement and like for a fence, or I was in court today for a piece of concrete that was extending beyond the property line. You can't get an exclusive easement for an encroachment. And that's the Hirschfield versus Schwartz case discusses that in like the neighbor context. And that's why the judges in that case said, well, we can't give you an easement that you want. It's exclusive and nothing else can go on that part of the earth where you want this encroachment to remain. So we gotta, I don't know if they made up the law, but we gotta have the law evolved and come up with a new theory, which is an equitable easement, which then could maybe give you that exclusive right. And then you're gonna have to pay for it.
Interesting. Okay, very good. Let's go to the next slide, please. So the client calls or walks in the door with a pile of documents. Maybe it's a title report, maybe they've got some deeds, maybe they've got some historical images of what's happened out there or what they knew when they bought the property. Stephanie, where do you start? How do you assess these matters?
The first step I usually ask the client is, okay, maybe you've got this easement document, but have you obtained a survey? And I think a survey is important because a lot of times these disputes arise because people see a fence or they see a wall and they assume it's a boundary line, or there's a driveway they're using and that's what they think is a part of their land or the right to use it. But a lot of times you really don't know until you get a survey, and oftentimes you can be surprised. So I think first step in assessing an easement is to identify the location, the size, and the historical use. You review the recorded document, and then the next step is reaching out to a surveyor to kind of map the easement on the ground, especially when there's language in the deed that may be vague or refers to general locations. For example, I'm not a surveyor, obviously, but legal descriptions can say X amount of feet wide, 5 feet long along the X boundary line. Well, if you don't know where the boundary line is, you're not going to know where the easement is. There's also all kinds of surveys, and sometimes when you hire a surveyor, they'll do a survey and you'll get a boundary survey. But if you don't have the physical improvements, which is usually called a planimetric survey, or a topographic survey, which shows the different elevations, you're not really going to understand where the boundary lines and the easement lines are located in relation to the physical improvements on the land. So that's important. At the same time, though, sometimes the answer can be bad, and the survey not having one can kind of leave the door open, whereas a survey may confirm, my fence is like 5 feet on the neighbor's land, or that corner of the building is 3 feet over. What do I do now? So it's good to discuss it with the client and kind of figure out what the situation is before you also spend the time and money to do a survey. At the end of the day, the other side can get a survey too, and there's a little known law that says surveyors can go onto somebody else's land to complete the survey work without liability for trespass, but not sometimes don't have it right out the gate, And lastly, Zach and I really like to visit the properties. I think it can really shed light on the case in ways that photos will not do us justice. I remember there was a property out in Palisades, in Palos Verdes, and they were fighting over this land and they were spending all this money. And we went there and we're like, wow, this is just like a steep dirt area. What's going on here? Same thing with a case that Zach and I worked on showing, where we really didn't know what the topography is like, but we literally climbed up the hill. I climbed up there in a kind of a suit outfit, wrong shoes that day. My phone slid down the hill. Good thing it made it. But those are the kind of adventures we encounter when we do site visits, which always helps the case. The next thing is like reviewing the easement itself. So if it's a recorded easement that Zach talked about, there's usually a written document that's been recorded that tells you about what the terms of the easement are. It has a description of where it's located, It describes the scope of the use and perhaps some ancillary rights regarding maintenance and other things like that. And interpreting the easement is much like interpreting a contract, but there's the additional aspect of historical use. For example, if an easement's for ingress and egress, the purpose of it is to enter and exit the property. Maybe there's a certain type of use only used as a driveway. Maybe it's pedestrian. It can govern the scope of the easement going forward, depending on the parties use it. But that easement's not really meant for utilities unless it's expressly stated or reasonably implied. There's two kinds of broad category for easements. One is pertinent, which means it's tied to the land, and the other is engross, which means it's personal to a party, like a billboard. A pertinent's more like a driveway. And misuse or overburdening the easement can give rise to claims or modifications. That's when people end up calling our office. Or if their language is ambiguous, much like a contract, in some instances, they can allow exchanging evidence to determine intent. And the title reports, if it's recorded, they can usually help with that because it'll be a recorded document that your title company can pull that we'll be able to review.
Is that where you start? Do you start with the title policy in these cases?
Sometimes, yes. Not everybody has one, or maybe people don't know where it is. So sometimes we get a case and we want to know, we don't have a copy of the easement because let's say we don't know the date it was recorded or the recording number. We just know there is an easement. We'll, call up a title company and ask them to pull a preliminary title report, which usually lists things that are called exceptions that are recorded against property that we can then obtain a copy of, and then we review it. Sometimes clients have it. Other times it's directly in the legal description for the deed itself. So we may not necessarily need to get the title report. But usually, and Zach will talk more about this when we do a quiet title action, it makes sense to get a title report just to see what else is out there.
Can you ask the title company in those situations to map the easements for you on a sheet of paper so everybody can sort of see it and how it relates to the property? Or do you usually have to hire your own experts to do that?
I haven't really asked for that. I think sometimes in the context of a transaction, it's
Yeah, I
sometimes
think
an
ahead of
ulta.
time, you can ahead of time, if you're buying that as part of the policy, you can ask them to identify it. But usually if it's coming to our office, it may be 5 years later or something, and they're not going to do it. So it's my experience.
You
But
gotta
you could
hire.
pay.
Your own experts to do it?
Yeah.
Yeah. So, and then usually we recommend that. And again, most people don't have a survey. Sometimes there's a survey recorded, but even that won't tell you exactly where the physical improvements are because that's not always a requirement. So, yeah. And then kind of talking more, learning about the scope and interpreting the survey at the easement. We then kind of want to know more about potential repair and maintenance obligations. So the general rule of law is unless otherwise agreed, the owner of the dominant estate, which is the party benefiting from the easement, is typically responsible for the maintenance and repair. However, in certain situations where there's multiple owners using a survey, which could include the servient tenement, the cost can then be shared in proportion to use, divided among those multiple owners. And the civil code section that governs that is section 845. So, a lot of times we have clients come in and we just did this case related to maintenance of a driveway, long driveway of a property out in La Cañada. There was a maintenance agreement. Unfortunately, it was not a model of clarity and heated litigation resulted because of that. But in that case, it was interesting because the driveway, which was used by everybody to access their property, their flag lots, and one property was landlocked, imposed an obligation on the parties to kind of split the expenses, but then also divided up the driveway to say, hey, you've got to pay 100% because this part only accesses your property. Interestingly, there was actually a third homeowner that used that driveway easement that wasn't part of the maintenance agreement. So there was some discussion on, well, general uses, dominant tenement must pay for the use, multiple owners needs to split among the parties, but then there's this agreement which splits it 50-50. Who needs to do this here? I'm not sure the law is entirely clear on that. We didn't litigate it all the way through, case settled like most cases, but I think there could have been an instance where the parties could have split it, and maybe us as a dominant tenant could have then gone to that third party and say, hey, you need to also pay for part of this because you're using this too.
Got
So,
it.
when you're looking at easements, a lot of times they don't have a maintenance obligation, so you kind of default to the law, but other times there is an agreement, and important when you buy a property that you look at that and know what you're getting into.
I know you folks mostly come in later after there's a dispute, but it sounds like people drafting easements should be thinking about those repair and maintenance obligations.
Yeah, and sometimes when we are, even though we're mid litigation, a lot of times most cases settle, right? So we are then tasked as part of the settlement to draft easement. And in those easement agreements, we then try to negotiate between the parties to figure out who's required for maintenance, just so that this doesn't happen again. So it's important to think about that if you're creating easement, even part as a purchase, or when you're doing the settling and easement dispute, if there's an easement being granted expressly to discuss their maintenance and repair obligations up front.
Yeah, makes a lot of sense. Let's go to the next slide. All right. So Zach, you now have a dispute. Maybe you've
Good.
written letters back and forth. I don't know how well that always works. Certainly there's a fair amount of litigation in this area. This is an advanced class today, so give us your best litigation tips and advice.
Yeah. So let's start with striking first. Oftentimes lawyers think that striking first, I'm going to send the letter first, I'm going to file the complaint first, is generally, I think it's a well-known practice that's usually a good idea. I would suggest to you that in an easement case, it's more nuanced. A lot of our cases, there's a heated dispute, and maybe an inexperienced lawyer or someone that doesn't practice in the real estate world regularly sends this nasty letter to us or to our client saying, you're trespassing on our property. You've been doing this for 6 years. It's finally come to a head. And if you don't stop, walking a car, driving on our driveway, whatever the situation may be, we're going to sue you for trespass and seek, crazy damages. And then we get that letter and we're like, thank you. This is awesome. We now have our prescriptive easement from your lawyer. Because a lot of times when they send these trespass letters, we can accept those letters as maybe even true, and then flip them on their head and say, well, now we have all of a prima facie case for a prescriptive easement. And my exhibit 1 to the complaint is the letter that gives us all of our elements, because there's no tax element. So my suggestion is think about what your ultimate theory is going to be if you're going to send the letter first. If somebody else sends a letter and it's super nasty, then probably thank them, because chances are they're going to have said the wrong thing. And this kind of flows over into, once the letter writing campaign doesn't work, which it often doesn't, is filing the complaint and who goes first there. Most of these easement type cases where you're arguing over sort of the establishment of an easement as opposed to rights under an easement, which we do those cases too, where there's an express easement, but someone needs to interpret it. But on the establishment of an easement, these are quiet title cases generally, and that's the umbrella term I usually use. It's like cause of action number 1, quiet title / easement by prescription, maybe the case. When you're doing these are verified complaints, because quiet title complaints need to be verified. So unlike other areas of law where you can have alternative theories, it's very tough to have alternative facts that would lead to alternative theories that are true as under penalty of perjury. So that in the Bata case that I mentioned earlier, this was a Court of Appeal decision where I guess we didn't win at trial, but we certainly won on appeal, where the plaintiff made the mistake of saying, look, the purchase and sale agreement in that case they had made a weird argument that the purchase and sale agreement granted an easement because it referenced in the disclosure the existence of an easement. And so on the one hand, they argued that there was an easement by grant, which the Court of Appeal disagreed with. And on the other hand, they argued that there was a prescriptive easement. And obviously, if someone's granting an easement, then they're not giving you permission. So those were like fatally inconsistent. And that's the bulk of the opinion in the Bata versus Hunt case. But it highlights the tip I'm giving right now, which is you got to pick your theory and you got to make sure it's consistent. So sometimes I did a case in Malibu, or beautiful property up there, where I knew I wanted to have these inconsistent theories, but I couldn't make it work in the quiet title context. So I alleged that there was a prescriptive easement. I waited for their answer, basically denying it, and then I was able to use their answer to alternatively plead, saying if I sued Gideon, Gideon is, I have a prescriptive easement over Gideon's property. He responds back and says, no, you don't, for this reason and that reason. I then cite to his answer saying, if what he's saying is true, then I have this claim. If he says he gave him permission, typically I would spin to an irrevocable license, and that's not what we're talking about today. But it allows me to give some inconsistent theories based on somebody's answer, and that's my workaround on that. Another, if we sort of shift into the law in motion practice, in terms of you've got through the complaint and obviously the letter writing, to the extent there is some. In law in motion, a lot of these on the prescriptive easement cases in particular, someone is trying to block access. I've had this in the commercial context over and over, where there's a shared driveway of some sort and someone tries to stop our client from using the driveway. We'll run in, file our complaint, and seek a temporary protective order pending hearing on a preliminary injunction. And we routinely get these. And these are they're great to have, obviously, for continued use of a driveway or whatever the situation may be, but they're also really valuable because you got a judge telling the other side at the outset of the case, oftentimes day one or within a few days of filing the case, that, hey, it looks like this side's going to win, right? Because there's an evidentiary component to this. So very valuable, and also allows for continued use and can ultimately lead to contempt, which I've done in this context as well, where someone then still blocks it. So these are probably the nuts and bolts of the most essential tips. Most of these cases do not lend themselves to summary judgment, would be my take on any of the easement ones. There's usually somebody's arguing about permission, equitable easement, if someone's negligent or not negligent. So I had 2 summary judgment hearings on a prescriptive easement case this morning, but it's the rare or the exception. So those are my overall tips. I would say money's generally not a big part of these cases. I mentioned it earlier with respect to an equitable easement that you may be able to get a severance, basically appraisal, where if you're successful in getting an equitable easement, that you have to pay for the use. But beyond that, there isn't much. The money's, maybe sue for nuisance or something, and you get some, I don't want to call it pocket change, but not justifying the high cost of the litigation just to seek money. Usually these cases are driven by a need for those extraterritorial rights, and that's worth it. One other point, which a lot of people don't know about, but does come up from time to time, but often many judges don't know about this as well. There's Evidence Code 662, which creates a presumption that records, and this doesn't just apply to easements, but it does apply to easements as well. There's a evidentiary code presumption that says that record title is basically presumed to be how the world exists. And if you want to do something, you want to put me on title, or I want to put an easement on your title, when then I have to get beyond the preponderance of the evidence, I have to get to clear and convincing, which in theory makes these cases a little bit more difficult from an evidentiary perspective. My view, and a good tip to have prior to heading into any courtroom, is judges are not different than everybody else. They think the property lines are the property lines, and that's the end of the story. And so you have to fight and fight. You're not just fighting opposing counsel, you're fighting the judge who does not want to believe that you can go beyond the property lines. And you can always get there, because I think most judges listen. But you have to know that walking in, I think you're disadvantaged if you're trying to get what I deem extraterritorial rights.
Interesting.
I think I can pass it off.
Yeah, interesting to sort of overcome that presumption. Let me ask you a question about sort of the evidence in these cases. What evidence do you need to win? Is it very expert heavy? You're relying on depictions of the survey with hatch marks and shading, declarations, aerial photos from 30, 40 years ago showing what the driveway or the encroachment looked like. All of the above, very factually intensive cases, right?
Yeah, I think it's all the above. Most of I mean, a survey is an opinion still, but it shouldn't be in a normal, like in a normal neighborhood. It shouldn't be difficult to figure out where the things are. But I put on like family photos, not of mine, obviously, of a client on a driveway to show that they were using the driveway and their kids growing up playing on the driveway and washing the car. I put on at one trial, we were arguing overburdening of an easement. We hired an expert to basically have a drone for 8 hours, and then we sped it up and played it for the judge. All the cars coming in and out of this like tiny little driveway that were my client owned, but was sort of partially burdened with an easement for like a pretty famous restaurant in LA. So all the above. But it tends to be less expert heavy. I mean, you're going to have your surveyor, but sometimes I even offer to the other side to let's just stipulate to one surveyor can go out there and figure this out. It shouldn't be that big of a dispute over the survey itself. But there's less of like, I've testified as expert in easement cases probably several times. It's usually only because the judge wants someone to explain it, and it's been at their request, not me, obviously, but to have an expert. And that's because usually I think they're not expert dependent. It's more factual dependent.
Got it. That's helpful. Let's go to the next slide. All right. So lis pendens. Lis pendens means suit pending. A lis pendens is an official recorded notice to the public that a lawsuit involving a claim on the property has been filed. It clouds title. It's used to protect the status quo and certainly, Stephanie, to get the other side's attention. So let's talk about quiet title litigation and lis pendens practice.
Yeah, so we've already kind of talked about what a quiet title action is, right? And as Gideon previewed, a lis pendens is usually a requirement when you file a quiet title lawsuit. And it's a statutory procedure pursuant to Code of Civil Procedure section 760.010. And as part of the requirements, the complaint must be verified when you file the verified complaint for a quiet title. So it doesn't really change the effect of a judicial admission, but it's just one extra level where it's a verification. So you could just imagine opposing counsel parading the complaint during a deposition on the statements in there. So it's important to get it right. Complaint must have a description of the property. Usually that means a legal description. You can get that from the deed. Another reason why a title report can be helpful because it has the best and most official description for the land usually. And then the lis pendens, you need to, right after you file the complaint, because you need the case number, you have to prepare it, sign it, and as part of the lis pendens, you've got to properly serve it, which the service requirements are important because if you don't follow them, it actually is not effective. So you need to figure out all the known addresses of the adverse party, so everybody you're suing, which can sometimes include the lender, because as part of a quiet title action, if there's a party that you want the judgment to be binding on, you should name the lender and any other parties. So oftentimes, in the abundance of caution, we'll identify the lender. They're not really disputing. They don't really care about whose fence is where, but they want to just make sure that their claim is priority. So we name the lender, we serve them, and then usually you work out a deal where they don't have to participate, just so there's minimizing the fees on that front. The other parties you need to serve, which needs to be by registered and certified mail with return receipt requested. In addition to the adverse parties, are all the owners of record as shown on the latest county assessment roll. And that can help, title company can help with that with a preliminary report. Sometimes there's a bunch of people out there that is defendant out there. Sometimes we sue dead people. Sometimes we sue estates where we don't know the address. And that's usually, there is a way around that, which is you just have to look and then provide a declaration. And a failure to meet these requirements can make the lis pendens invalid. And basically what a lis pendens does is it gives constructive notice to everybody that there's a lawsuit pending. So if somebody, transfer the property or somebody tries to obtain a loan, you'll have notice of the lawsuit. They'll be subject to it. You'll have priority. So it's an important and useful requirement. And people don't like it because it clouds title. So the second you try to sell the property, buyers going to find out once they pull a title report that there's a lawsuit pending. You try to refinance, lender's going to see there's a lawsuit pending, and that applies pressure on the other side because their property is basically locked up until the lawsuit's resolved. And then as part of the quiet title I previewed earlier, you may want to get a title report to identify who potential adverse parties that you want to be subject to it. There's actually one step above a title report, which is called a litigation guarantee, where you actually obtain sort of a guarantee of the title from a title insurance company that says, we have done a search. These are all the parties that are on title. You can be assured that there's nobody else out there, so that if you sue all these people and it turns out, oh, they forgot to name this lien holder so-and-so, you'll actually have a policy with the title company and to protect you in that
And
instance.
you can do that for somebody else's property?
Yeah, you can.
Interesting. Okay. So once the list is on record, people sometimes work real hard to get it removed, right?
Yeah, and there are instances where you can remove the list pendants. So even though it's a requirement when you file a quiet title action, there is some consideration of, ooh, do we really want to take that step here? Because there is a procedure where you can file a motion to ask the court to expunge the list pendants, or you can demand somebody remove it by threatening to bring that motion. And the teeth of the motion to expunge is that A, there's an evidentiary and burden of proof that you need to show a probable validity of the claim. Basically, let's say you're the defendant, plaintiff records a list pendants against your property. You say, I don't think you're going to win, blah, blah, blah. You send a demand letter. Plaintiff doesn't do it. You file the motion. And then plaintiff is sort of in the position to show that they have a probable validity at the outset, mostly to prove their claim. And if the moving party wins, you can also get attorney's fees. And the last bad consequence for the loser in this situation is that maybe a little known fact that once a list pendants is expunged by the court, it's as if the list pendants and the lawsuit almost doesn't exist, because the person whose property was encumbered by the list pendants could theoretically transfer it to somebody. And even though that transferee knows about the lawsuit, has actual notice of it, it's as if it doesn't exist. So they don't take subject to. So, just
it's worse than it having never been there in the first place, right? Yeah.
Right. So sometimes you may want to make the move to remove it, or you got to consider, something you really think about when you're thinking about your theories of the case and when you file the lawsuit and understanding the requirement of list pendants. Think twice, think carefully before you do that and pull the trigger. And sometimes it can happen where if a plaintiff successfully defeats it, they can also ask for their attorney's fees. But, there's a lot of discretion and variability on whether the judge is going to be willing to do that or not. That's what we've seen.
How does the judge, in your experience, once you have defended your list pendants, or once you've had it expunged, are you able to negotiate the attorney's fees, or how do judges look at attorney's fees, or is that just part of the overall risk in going forward with this procedure because you never know?
I think it's probably the latter. I mean, I've really seen judges run the gamut. Sometimes they give every penny. Sometimes they don't. Sometimes they use the Laffey matrix, which is a way to identify the market rate for our fees, which may be more than the client paid to get more fees than our client actually paid to us. There's a lot of variation there, a lot of discretion with the court. So hard to say.
Let me ask you this then before we move on to the next slide in the 20 minutes we have remaining. In your cases where you're the plaintiff and you're coming in, are you filing list pendants in these cases, or do you think really long and hard before doing it?
We usually do it because, we are in the practice of not filing frivolous lawsuits. So we've looked into it beforehand. And also, to tell you the truth, a list pendants losing that motion, let's say the plaintiff loses a motion, it's not dispositive. There was a case that Zach and I did where we lost a motion to expunge a list pendants and we ended up winning at trial. So it's not great that you lose it, but it's also not the nail in the coffin because it doesn't govern the rest of the case. And you usually haven't done the discovery and done all the work to work the case up. You learn something as you you could still win, but it's not a good foot to start off on if you lose right off the bat.
Let's go to the next slide. So a title insurance is a key part of these cases. You can get defense, you can get indemnity. Sometimes even they can prosecute claims for you. But, in my mediation practice, though, I see that lawyers don't always realize that or are not aggressively including and thinking of the title insurance as part of these cases. Stephanie, let's try to get the participants today more comfortable working with title insurance.
Yeah, so most people, when they buy property or get a loan, it's an insured transaction. And that means you get a policy of title insurance, which, as discussed, verifies who sold you the property, verifies what the legal description is, identifies exceptions, and then it gives you an opportunity to review the exceptions, which are liens, property taxes, easements, those sorts of things. And so as part of, obtaining title insurance, it's important to review each of the exceptions, identify the liens, easements, and then look at the underlying documents to see exactly what you're getting into so you understand the expectations of use and maintenance and other things. And then once you get the policy, keep it in a safe place. Don't forget about it, because if a dispute arises regarding title, let's say you try to refinance, let's say you try to sell a property, let's just say something just comes up. It's important to also understand the reporting requirements when these claims arise. And like many other insurance policies, you got to notify the title company quickly, sooner rather than later, because it becomes problematic if you've delayed and done a bunch of stuff and then they're not on board with it. And then there's two different kinds of policies that I've seen. There's ALTA, which is the American Land Title Association, and the more standard one is CLTA policy. And they're just two kinds of policy that provide different levels of coverage. And if we want, we could kind of go to that slide that describes kind of in a Venn diagram-ish form. So as you see here, there's a big circle, and a smaller circle. So the standard policy, which is again, is more like a CLTA policy. It usually encompasses the types of claims that are in this little circle, such as unmarketable title, someone else was interested in your title, improperly executed documents. Let's say they got the name wrong, the notary seal's missing, the APN is a little off or something. If there's some sort of forgery or fraud or duress, if there's undisclosed recorded covenants or things like that don't show up, or a lien. Those are usually all claims that are covered in a standard title policy. Now, there is a higher level ALTA policy, which usually costs more, which covers many more things. You can see forced removal of structure, this is an important one. So if you got a ALTA policy and there's a boundary dispute, and let's say there's a kind of structure there that violates a zoning law, you could potentially get coverage, which usually under CLTA you can't. So it's just more expansive. And I would usually recommend the client to spend a little bit more money up front to get the ALTA policy, because it's just going to cover more. And it's, but you also got to make sure you review your specific title policy. There's variation from underwriter to underwriter. So just make sure you review it carefully to see what would be covered and what's not covered.
If we can go back to the prior slide there, when you see these exceptions on the policy, I guess we go back, Katie. Have you had success working with title to get exceptions removed?
Yeah, you can. They resist, sometimes let's say there's like a deed of trust that's like 30 years or 60 years old or something like that, but nobody's ever recorded a reconveyance. There's law that says in certain instances, those things expire. So you can convince them, hey, this is expired. It's not a risk. Please remove it. In those instances, they'll remove it. Or let's say there's a lien created by a judgment lien, and you say, hey, that's the wrong person. This shouldn't be encumbering the property. You're able to do that. But they usually resist to getting exceptions removed, because that means if it's not an exception, if something goes wrong because of that particular issue, it'll be covered. So The exceptions means it's accepted from coverage. That's what that means.
So it can be difficult to get those taken out, working with the title folks. What about submitting claims and working with the insurer? How's that go?
I get a prompt notification, do that. I find that recently the first response is usually to deny. So they don't like claims like any other insurance company. They're no different. So it kind of gets adversarial, and it covers disputes, which you could spend all day on, and just involve kind of contract interpretation. And it's like other insurance policies. You threaten that there's bad faith. You try to argue that there's coverage, and that could theoretically get them to accept coverage under a reservation of rights. And on that note, usually even if there is an acceptance of the claim, it's almost always under a reservation of rights. And importantly, people don't know this, but the title company can elect, usually at their option, sole discretion, whether just to pay, which is something that they decide internally, or whether to provide defense and coverage. So if it's going to be cheaper for them to just pay you for what they think is covered. For example, we had this driveway dispute, and part of the driveway was located on the other side property, but it was like a beautiful long driveway, gave the client parking, kids played on it, and the title company only wanted to pay a little bit of money to remove a little bit of the driveway, that's just not going to work. It's like an engineered, beautiful driveway. You can't just remove part of it and just have it be in no man's land. And so they were insisting, hey, we're only willing to pay the $5,000 to remove it. We're not willing to pay for anything else, like moving the driveway, dealing with this problem, because just removing it doesn't solve the problem. And we had to get into a battle with them over that. So that's and they were like, we're not going to defend the case. And so client had to pay us. We ultimately were able to resolve it, but we really fight with the title company over that issue.
And then talk just for a minute between affirmative and defensive claims. Are they more likely to cover the defensive posture? Do you see them filing affirmative claims here and there?
Yeah, usually policy that's triggered is you get sued and you tender the claim to insurance. And so they're usually defending. That's more likely. Some instances where if the title is really messed up, like they miss something in the chain of title and you don't have marketable title, I have seen title companies file lawsuits on behalf of the insured in order to fix that problem.
When the easements are not of record, do they ever help you there affirmatively?
If it should have been a record and they missed it, they'll deal with that. But they are not usually trying to file a lawsuit to establish a prescriptive easement or any of that. You got to do that. And in fact, a lot of times we have a client who gets sued because they're encroaching, blah, blah, blah. And then they pick up the defense. But we also have affirmative claims. So they have to then hire us, even though they have insurance, to prosecute the cross claim. And so that's why mostly the context of insurance companies, I see it in defense most of the time.
So we've talked about indemnity issues. How about duty to defend? A lot of times they're going to retain counsel for you. Are there pros and cons to that?
Yeah, they retain counsel for you, but you're not going to have a choice. So they're just going to assign you somebody. I think not a legal thing, but from a business perspective, they've got a lot of cases. So it can be a situation where you're not getting the personal attention that you would otherwise get from private small law firm, but that's not to say that they're not competent at their job or they do what you got to do. And big pro is it's free, as in you don't have to pay for it. So, and there's usually no deductible.
Sometimes do you get taken out of the case once you find title insurance for your clients?
Yeah, and we're happy with that. I mean, it's it's the best for our client. And sometimes people call us, are like, we really want to hire you, and I'm like, have you tried title insurance? It's going to be free. Why don't if you need help navigating that, we're happy to do that. And then once you get coverage, we can be out of the picture. Or if you want, we can stay on behind the scenes and answer any questions you have if there's reservation of rights or you're just not sure about what's going on. But yeah, we're happy to pass it off because that's what's best for the client there.
Yeah. Let's go to the next slide. Zach, homeowners associations or HOA disputes are similar to a lot of the neighbor versus neighbor cases. It's a lot of emotion, a lot of the same types of cases. but you layer on it the whole statutory scheme of Davis-Sterling, governing documents, boards, decision makers. Thankfully, ADR is a component here. But please talk a bit about your perspective on HOA disputes.
They're generally a can of worms is my entire, no, I'm just kidding. No, the reality is they're difficult, and we do a fair number of them. A lot of the same issues that arise in easement cases arise in HOA disputes. The key difference is you have a whole, like the Davis-Sterling Act is a very long set of rules that you have to rely on, and then you get to also layer on the CC&Rs. So there may be even a subset of rules. So I see these in all contexts. It can be everything from maintenance and repair obligations. I see that's a little less. Maybe the board is doing something wrong. I had a case out in the Valley years ago where there was like I don't know what the proper term would be, someone who was exercising undue control over the board and getting personal favors allegedly in exchange for getting architectural plans reviewed. And so we had to come in and try to take that gentleman down, using the term gentleman loosely, and so that we could get our construction approved. It can be over like enforcement of CC&Rs. It could just be like we've had cases where in condos where if you're going to put hardwood floor on the second floor, you have to have a certain amount of cork so that you don't have a loud walker case.
I had one of those recently.
Yeah, you see it all. I've got one right now in Ventura County, which like barreling towards trial in August or maybe September, over where they built an entire neighborhood on the water where they had granted like a 5-foot or 4-foot, I think, easement for the neighbors to use each neighbor's side yard. And then there's an issue over what you can use the side yard for. And so that's like very contested. And that really involves sort of bullet 2 on this slide is interpreting the CC&Rs. And we're having a giant battle over I won't get into the details since it's so close, but over 2 terms, and I'm deposing the city. I've done it twice over how they define X term, and the other side is arguing X means Y. So those happen. We have other cases where you're dealing with a homeowners association and they're not necessarily a part of it. I just settled a case, I believe, like, I don't know, 3 hours ago. We got it finally signed where a homeowners association is adjacent to my client's property, and they were claiming that they had an open air restriction, basically, that my client couldn't build on his property, and tried to prevent him allegedly from selling the property. And so we got into the case like 2 years old and literally signed at like 11 this morning, maybe 10, and resolve that dispute. And part of the resolution of that dispute, going back to Stephanie's point on insurance, is the HOA had a big policy, like $1 million policy. And so they were getting their defense paid for on I think on directors and officer liability. And also it brought money to the table to help us to be able to hopefully in a good way resolve the dispute. So that's a very brief overview of types of HOA disputes. I've got another one, actually, an easement one, HOA in Contra Costa, where we're trying to get an easement by necessity, but we're trying to basically go through the neighboring HOA. And so another situation where it's an HOA dispute, but we're not internally a part of it. Anyways, moving on to business judgment rule. I think that's probably self-explanatory to most people in the room, but the HOA gets to make certain decisions and they get to enjoy the benefit of a business judgment rule in their board decisions or maybe even executive session decisions. Germane to today's seminar is, and a favorite of Gideon, I'm sure, and ADR in particular, is a lot of these CC&Rs and even the civil code dealing with the Davis-Sterling Act mandates sort of a pre-lawsuit mediation for internal dispute resolution. Sometimes there's an arbitration provision as well. And so this can be a condition precedent before you can actually bring a lawsuit. And these are like so good. I think these ADR, at least mediation, and we see them all the time. Stephanie and I deal with them constantly in the CAR form, the California Association of Realtor Mediation. These are prerequisites usually to recovering your attorney's fees. And so it forces us all to get help, go to someone like Gideon and get good help and try to resolve it before tempers flare and before the costs get out of control. So I always view them as a good thing. The only bad thing is scheduling them. It's generally impossible. That's my experience. And maybe ADR has the magic solution on how we cross that hurdle. So that's a big part of it. I talked about the sort of the fourth bullet point already, the role of insurance. It can be a good thing. Obviously, if you're getting sued and you're on the board, that can be great. If you're like the instance I gave, this case I settled this morning, it's great that I was able to get my client a ton of money. And that came from insurance. The board represented even in I think in the settlement agreement, which is not confidential, that they had no money. So everything that was used to fund the settlement came from insurance, so that can be a good thing. But other times,
You
obviously,
find out if the HOA has insurance, or do you draft your pleadings to sort of trigger it?
I usually don't. Well, it's Frog one, like Form Interrogatory 4.1. That's what I meant to say. They have to respond to that, and sometimes you'll get enough info to, you're not going to know if they've reserved rights and if they're not really covering it. Maybe that comes out in a mediation. I don't typically draft things to trigger insurance, sort of unlike a PI practice. It happens sometimes that insurance is triggered. I think sometimes I will draft things to avoid insurance being triggered, and that's more often in the easement situation where if you sue for nuisance or trespass, you may trigger not necessarily their title policy, but you may trigger their homeowners insurance policy, and then they get their free defense on that because you're seeking like minuscule damages for the trespass and nuisance. So that's something I'll sometimes factor in because that can create endless litigation but
Good.
yeah. So
Okay. All
probably
right.
out of time on my side. I want to leave you whatever time we got. Get in.
Yeah. So in the last 5 minutes, we'll talk a little bit about settlement tips in these cases. Let's start with mediating with multiple parties. These types of cases can often involve multiple decision makers. For HOAs, you have the board, where there are multiple personalities, sometimes drama, right? Or a management company, maybe you've got indemnity claims. The best lawyers and mediators are thinking through at the outset, anticipating potential conflicts, potential relationship red flags. And this can't be overstated. In a mediation, in a negotiation, every person in the room matters. There's a reason why they're there in the room. Lawyers, board members, could be family members. The best negotiators and mediators try to build rapport with everyone who matters. Of course, you prefer one point of contact. You don't want to be herding cats. You do want to encourage the clients to speak with one voice, or at least anticipate a process for streamlined communication. And communication is key. Nobody likes feeling in the dark. You don't want to let feelings or concerns about the process poison the well. And that relates to rapport building, trust building, making people feel heard, listened to, showing empathy, being available, cultural competency for everyone in the room. What's below the iceberg? Mediators use the analogy of an iceberg. We can see the iceberg. It's the lawsuit and the parties' litigation positions or money demands. But what's beneath the surface, below the iceberg? Motivations and interests. Easement, boundary, and HOA disputes often are about more than just money. They may involve mitigation or repair, construction design, creative settlements, or improving communication. Mediation allows for exploring what's beneath the surface and for creative brainstorming of the non-monetary terms. Choices, BATNA and WATNA. The goal of mediation should be to present the parties with a choice. Mediators don't make decisions. We're not judges or arbitrators. But the mediation session should not end before the mediator explores with the lawyers and clients what it's going to take to settle the case. What are the best terms after hours or days that we can get from the other side? Then we can discuss BATNA, the best alternative, and WATNA, the worst alternative. The parties then have the information to make an informed choice, settlement, or more litigation and trial. Now, this may be counterintuitive, but sometimes expanding the issues can help getting a deal done, whether it's money, repair, construction design, access, a process to improve communication. The more issues on the table, sometimes the easier it is to gain concessions, momentum, and agreement, at least on some issues. All the issues become currency that the parties can exchange back and forth for negotiation. It helps create non-zero-sum negotiation and the ability for win-wins. Transformative relationships and early mediation. There's a lot of theory and research on early facilitation and mediation to save costs. If emotions are high and repairing the relationship is important, which is very common here because there's a continuing relationship, almost like family law cases, think about joint sessions. Think about a mediator trained in facilitation. I had a homeowners association case recently. We got the parties in the same room. At first it was tense, but ultimately it was really a transformative moment and the case settled. And do the outreach. If the party's willing to mediate, willing to sit at the table early, take the opportunity. And one good tip for this is to prepare draft term sheets before you engage in settlement. Put the work in to identify the key components, even if it's just for your own internal use, for your internal decision makers. This will give you a roadmap of where you may end up. And also, once you start circulating a term sheet, puts the other party in a settlement mindset. We stop thinking about litigation positions and more about the party's interests. We start identifying terms that are important. These then become the currency for the negotiation. I had a mediation with Zach recently. It was in person. The parties and the lawyers worked off a term sheet that the lawyers then refined and negotiated, and the client signed, all in person that day. So those are some ADR and settlement tips. We'll go to the last slide. I want to thank you, Zach and Stephanie. Thank you, Katie. We covered a lot today. We have so many questions in the chat. We don't have time for that. There's 32 questions, but you can reach out to Zach, reach out to Stephanie or me. Think for yourselves when it comes to good fences, good neighbors, which side of the fence you and your clients are on. And stay tuned for a huge webcast, September 10th, on land use and environmental permitting. ADR Services and I are going to host New York Times #1 nonfiction bestseller and #1 Apple podcaster, Ezra Klein. Yes, it's true, for building what California needs: abundance, policy reform, and dispute resolution. Mark your calendar, September 10th for that, and stay tuned. In the meantime, I want to thank you all. We'll see you at the next mediation.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.